So I think with that, we will kick it off again. I think people are starting to come back in. And I just remind everybody there is a Q&A function. So get your questions in there. And we will have an opportunity again after this first panel for people to pose questions. The first panel is looking at the current developments in investor-state mediation. So it's really looking at the current landscape and where we are. We've got a great group of panelists who have been very much involved in the development of this field now for several years. And I will just go through quickly who they are. We've got with us Alejandro Carbello-Leda, who is the GC of ECT, the Energy Charter Treaty Organization. And he's been very much at the forefront for the last 5 years of assisting the Energy Charter Treaty Organization to implement mediation and putting the necessary tools in place for that to take place. So we'll hear from Alejandro. We have Mark Appel with us. Mark has spent most of his professional life actually in mediation, many years, probably over, I won't say how many, Mark, but Mark has been instrumental in also helping to develop, in particular, mediator competency criteria through IMI, the International Mediation Institute, and he led a group looking at mediator competency criteria for IS mediators. So we'll hear from Mark on that. We've heard from Meg already with respect to ICSID, but one of the key individuals who's been involved in mediation within ISDS long before any of us really were, and that's something that goes back and goes back several years, and that's Frauke Nitschke. So Frauke is going to talk to us, as Meg suggested, a little bit more about the proposed ICSID mediation rules, but Frauke was also instrumental in the IBA mediation rules, which goes back all the way to 2011-12. So Frauke has a lot of experience there. And then we're also fortunate to have with us James South, who is the managing director of CEDAR. And CEDAR has also been a driving force behind particularly the capacity building that is needed if mediation is going to play a major role in ISDS. And so James will talk a little bit more about the capacity building side of it. But if we could start, Mark, with you and looking at mediator credentialing in this particular field, perhaps you could take us through that.
Sure. Thanks, Wolf. Just to start by saying what a pleasure it is to appear on this panel and with these people and these institutions. You talked earlier about institutional leadership, and I think there's been extraordinary personal leadership as well, and I would count everybody on this panel among that group. So I'm thrilled to be with all of you. So thanks for that. I'm going to talk mostly about the IMI, that is the International Mediation Institute, Investor-State Mediation Task Force, and spend most of my time on quality standards and on the IMI IS mediator competency criteria. But you know, it goes back a bit further than that. So 2012, the International Bar Association came up with a set of mediation rules for investor-state mediation. They apparently felt that investor-state mediation was different, and recognizing that, I think also recognized that rules are important, that they legitimize and normalize process, and they incorporate best practices. So a wonderful group of people undertook to create those rules. In 2014, the IMI, International Mediation Institute, I think recognized an opportunity to support this really new interest in investor-state mediation and created the Investor-State Mediation Task Force. Interestingly enough, bringing on board many of the same people who created the IBA mediation rules, including both of its co-chairs, Anna Jubin-Brett and Bart Leckham. But IMI has always worked best in concert, in mediatory fashion, collaborating with institutions and individuals and academics and leaders. And so IMI created the task force, and as one of the first pieces of business the task force took on was to provide guidance. Okay, that we have a set of rules. What we don't have is a ready pool of mediators to take these cases on. At least that's how it was perceived, and I think correctly perceived. So the task force decided to turn its attention to providing guidance to investors and states, to appointing authorities regarding helpful experience, expertise, and skill sets that would work well for mediators or persons who hope to serve as mediators in investor-state disputes. That process took some time, not surprisingly, and 2 years later, I actually took on the chairmanship of the task force, with much of that work, I'm happy to say, already in place. And in September of 2016, IMI published the competency criteria for investor-state mediators. The criteria lay out 6 different areas for examination. First is understanding of investor-state issues, fairly obvious. The second is experience and mediation and other dispute resolution processes. Here, important to understand that IS mediation, investor-state mediation, frequently will take place in anticipation of or in the shadow of other ongoing or soon to take place actions, whether those actions be an investor-state arbitration or a civil litigation in some jurisdiction. So having that experience in a broader experience in dispute resolution processes is important. The third criteria was experience with different forms of negotiation, mediation, and conciliation. We mediators we take disputants as we find them. And they frequently come from different places. They come from differing legal traditions, different cultural traditions. They communicate differently. We don't have the opportunity to make everybody communicate a single way or think a single way. And so finding ways to communicate effectively and to work effectively with those people is important. What works is good. And so mediators are almost by definition flexible people, able to work in lots of different environments and do so successfully. The next criteria was understanding of arbitration and adjudication. One of the important roles of a mediator is being able to address or assisting parties in addressing the what ifs. What if we don't reach a settlement? What's going to happen? What's likely? What are the best or the worst alternatives to a negotiated agreement? What are the consequences of impasse? And so having a mediator who understands how what's it going to cost? Counselor, help me. What will it take take this case through this pending arbitration or adjudication. And so having the ability to communicate and understand those issues is important for investor-state mediators. The next issue, or the next issue for examination, is intercultural competency. For years, as a executive of an administering institution, we used to look at people and say, how effective is this person, not just knowledge-wise, but in an international setting. Will they travel well? Can they go outside of their own milieu, their own jurisdiction, and be effective as a neutral? And so, we sometimes say when I lived in London, we used to talk about football teams that didn't travel well. International mediators and investor-state mediators need to travel well. I should mention in that regard that IMI does have a intercultural competency. And if you're interested in that issue in particular, that's a place to go. The website there, imimediation.org. The last competency provided for by the standards is other, sort of an omnibus, a catch-all. And there were several different pieces there. One, of course, not surprising, subject matter expertise. So a big infrastructure project wouldn't hurt to have some expertise or experience there. Process management skills, critical in a complex, by definition, intercultural, international mediation involving states and investors. And the last one I love is technological know-how. Now, this is 2016, but how prescient, knowing that now we do our work on Zoom. This is how we work now. So that's the standards. I think I can say that they have stood the test of time well. They've been used as grist for investor-state mediator training, and I think you'll hear from James on that. IMI didn't stop there, and while the standards were critical, the issues that were identified by McKinney, by yourself, Wolf, and others regarding what else needs to be addressed are areas where IMI and task force, the investor-state task force, have continued to work. So working with Alejandro and his fine organization in creating the guide, the mediation guide, but also a critically important model instrument, which I'm sure he'll talk about for states, working with UNCITRAL and ICSID and Frauke on, giving feedback on their rules. All by way of sort of institutionalizing and normalizing the practice of investor-state mediation. And I'll leave it to my colleagues to tell you more about each of those. The task force has a new chair. Shanti Abraham is the current chair of the IMI Investor-State Mediation Task Force. And I think from her very first communication with all of us, she recognized what COVID has done to this process and the impact on both states and investors with really serious supply chain disruptions, employee health, transportation issues, states needing to address budget shortfalls quickly to reflect health concerns and health emergencies in their particular jurisdictions. The message, I think, from Shanti, and one for all of us to remember, is that this is a time for renegotiation. This is time for mediation, for mediated solutions in these very difficult cases. Well, I think I'll stop there. Thanks everybody for your time.
Yeah, thank you, Mark. That was a great way to kick off the panel. And I think what we'll do is we'll leave questions to the end. I'd like to see what comes in on the Q&A box as well. And we'll have a discussion after everyone has presented. So what I will do then, Frauke, if I could turn to you and you can talk a little bit more about the developments at ICSID and in particular the proposed mediation rules.
Sure, I'd be glad to. Let me just pull up my slides. If you could indicate when you see it, that would be helpful. Yeah, oh, good. So thank you for having me here on the panel. I'm very excited to speak about ICSID mediation any part of day, really, as my colleagues and friends on this panel will know. And thank you to the organizers, Wolf and Jarek and Bickel's team behind at ICSID. We know how many people are involved to get a virtual hearing or conference off the ground. So I know there's a lot being done in the background. So diving into ICSID's proposed mediation rules, Meg has already created the ground for what I will speak to. And just as a starting point, what are ICSID's current dispute settlement services? And we looked at the beginning when Meg mentioned the conciliation and arbitration framework available under the ICSID Convention since the 1960s, which provide these processes for disputes arising directly out of an investment involving a state and a national of another ICSID member state. In 1978, so some 12 years later, ICSID's governing body adopted the additional facility, which is best known for arbitration and conciliation of investment disputes where only one of the disputing party has a nexus to ICSID membership. And at that point, there was a realization that maybe we expand the type of processes that we have besides arbitration and conciliation to fact-finding. On the green, in the green boxes on the slides, you see ICSID's other activities, which include administration of UNCITRAL, investor-state arbitrations, and also offering investment mediation, what we'll talk about more now. So what is the background? Why did we come up with the idea of investment mediation and a set of rules specific to that at ICSID? So we saw a trend in treaties that our member states adopted mediation as a suitable framework for the resolution of investor-state disputes. And we saw it in treaties alongside conciliation or arbitration. So there was a policy shift and an understanding that there are different processes. And I'll touch upon that a bit because it came up in the Q&A earlier. Alejandro's work on the guide on investment mediation within the Energy Charter Conference, where 57 of ICSID's 155 member states participated, was another indicator that states are really interested in some practical approach to mediation besides the policy level in treaties. And then, of course, we're talking here of 2018 when the ICSID mediation rules were first proposed. And there the international community worked on the development of the framework of the Singapore Convention, which has in the meantime entered into force on 12 September this year. And you may have participated in some of the webinars surrounding the entry into force where we spoke about its applicability to investor-state disputes. Statistics you already touched upon in the Q&A. So what do we know about investor-state cases? Meg mentioned that the majority of these are arbitrations. But within the arbitrations, we know that in about 35 to 40% of cases that varies throughout the year. So what you have here on the slides is the overall number. Parties do not seek a final ruling by the tribunal, but they either ask the tribunal to include the settlement in an award or they agree to discontinue the proceeding. So that is an indication that there is, in fact, a bulk of cases where perhaps facilitated negotiation might be more effective. And what is the goal of the ICSID mediation rules? What did we intend to do here? We obviously wanted to offer a flexible process that allows states to come up with tailor-made solutions for their disputes with investors. States had asked us to take an active role in the mediation because of ICSID's long-standing reputation as a trusted forum and a neutral forum in the resolution of investor-state disputes. And then, of course, my friends here on the panel who are experienced mediators will confirm that on average, a mediation, even a complex one, may not take as long or be as costly as a typical investor-state arbitration. And what did we do within the rules? We included provisions at the end on the termination to align the ICSID mediation rules with the formal requirements in Article 4 of the Singapore Convention, so that should a party wish to avail itself of the mechanism of the Singapore Convention after a mediated settlement is reached within an ICSID process, they may do so. So what's the nature of ICSID mediation? And here it requires party consent, obviously. The parties have the control over the process at the outset and throughout, which is what we call ongoing consent. And either party may unilaterally withdraw at any time. So this is one, for those of you who are arbitration practitioners, this is one of the main differences there as well, that you need this ongoing consent. We talked about the differentiation between mediation and conciliation within the ICSID framework, and conciliation is in the convention. We have them in the treaties, so that's why we obviously kept those rules in place and added the mediation framework to address these policy developments and also to make it more flexible and have certain process differences to the conciliation. So in the mediation rules, there is no three-member commission. There's no objections to jurisdiction or preliminary objections as they are enshrined in the ICSID Convention. And the scope is wider in terms of what we offer, and that is where we come to now. In our proposed rules, the Secretariat is authorized to administer any mediation relating to an investment that involves a state or an RAIO, and the parties obviously need to have consented in writing to submit that to ICSID. So what you see here is a very broad access, the mediation authorization to administer. What you do not see here is any link to nationality or ICSID membership. So the mediation rules are in that sense intended for all states and not just to ICSID members. A few words here on the process overview that our rules proposed. So we have the request for mediation at the outset. And here one important difference to the existing arbitration and conciliation rules is that you can file a request for mediation that already contains an agreement to mediate, a pre-existing agreement, we call this in the context of mediation. And then you may also file a request for mediation with an offer to mediate that the Secretariat then transfers and transmits to the other side, inviting that party to agree to the mediation or to reject that offer. And if the offer is accepted, the process of the registration continues. Once a request for mediation is registered, there's an appointment process for either one or two mediators by party agreement. So another difference to the conciliation process. Once the mediator is appointed, there will be brief initial statements by the parties, identifying the disputed issues and containing process suggestions to provide that to the mediator in advance of what we call the first session, and Meg had already mentioned that. The goal of this first joint session is to develop the mediation protocol, which will serve as the basis for the conduct of the mediation subsequently. And there, what is being discussed at the first session, sort of administrative aspects, language, venues, but also participation of people other than the disputing parties to the mediation, or whether the parties have agreed to not initiate or not pursue other dispute settlement proceedings while the mediation is ongoing. And Meg had already mentioned that within that rule, we also indicate that the parties either at the first session or shortly thereafter are asked to identify a representative authorized to settle the dispute and describe the process that is required for the conclusion of the settlement agreement, so that we link the discussions during the mediation to a possible outcome right from the start. Termination of the mediation, then a notice from the parties that they have reached an agreement, notice from the parties that they agree to discontinue, withdrawal from a party unless you have a multi-party scenario where the mediation continues if the remaining parties wish to do so, or if the mediator determines that there is no likelihood of resolution. And finally, if the parties do not take any steps after the registration to appoint a mediator, then the mediation terminates if there is no activity within 120 days. What are some general provisions on cost? The rules provide that the costs are to be borne equally by the parties unless they agree otherwise. Confidentiality, we already touched upon in the Q&A, and Meg mentioned it in her keynote. That is a topic of discussion, and what the ICSID rules provide after really thorough consultation with all of our member states, where there is a wide spectrum, as Meg already mentioned. The mediation information is to be kept confidential unless the parties agree otherwise. This might happen in their contract. States may have a policy decision in their treaties to identify what information should be public, and or if the information or document is independently available or disclosure is required by law. The mediation rules also have a without prejudice provision that's similar to what you see in Article 35 of the Convention that the drafters already had in mind for conciliation proceedings, and that is that positions taken, statements made, offers of settlements may not be used in any other proceeding unless the parties otherwise agree. We talked a little bit about combination of mediation rules, and maybe there is a bit more time in the Q&A later. How does mediation fit in? And the way we wanted to draft our rules is to leave the most flexible options to the parties. So it can be used as a standalone process instead of other proceedings, or it can be combined either before an arbitration is commenced or in parallel with an arbitration, where you could, as Meg mentioned, you could have a mediation that perhaps leads to a full settlement, and then it's up to the parties whether they wish to embody that in a tribunal award, or if you have a partial settlement on only some of the disputed issues, then the arbitration only focuses on these remaining disputed issues. ICSID's mediation activities, Meg named them earlier already. So we continue our member state consultations, and there is really a wide interest in that area on mediation. We offer investment mediation administration already ad hoc to our members or otherwise. Capacity building, we've already touched upon how important that is on various levels. And since 2017, we've done the Investor-State Mediator training together with CEDAR and the Energy Charter Secretariat, provided technical assistance workshops to governments, and have also done together with CEDAR and the IFC training for government officials in investment promotion agencies, or what you call the aftercare units that deal then with the disputes, to train them on the mediation skills. Of course, The discussion about reform and mediation also includes the cooperation with the UNCITRAL Secretariat and the Working Group 3 discussions. We're working on the model clauses. We're looking at checklists for state governments that Meg mentioned. And last but not least, the dissemination of information, awareness raising in various fora, here on our website, videos, other trainings, really a wide range of activities. And with that, thank you very much. And I hand back over to Wolf.
Thank you very much, Frauke, and very interesting. Anybody who has questions, please send them into the Q&A function, and we will have a Q&A session. So please do get your questions in there. Next, we've already heard a lot about the ECT. But now we're going to hear it from the person who's been significant in actually creating a lot of these initiatives, and that's Alejandro Carbello Leda. So Alejandro, take it away, please.
Thanks, Wolf, and thanks to the organizers. I think my main role has been to be lucky enough to gather a group of very interesting and passionate people and to keep things moving and rolling on. And I think the key word is always cooperation. That has been a great deal. Cooperation of many institutional organizations and many government officials, industry in carrying out all these activities. It's always a pleasure to be discussing, always with such a good friends and many more in the participants list. Many things have been already said, so I will just try to go a bit straight to the point, what the Secretariat, NHR Secretariat has done in 2014. Got a mandate to assist with offices, mediation, and conciliation, and to provide some neutral, independent advice and assistance in dispute resolution. Now, what happened since then? A lot of things. You heard most of them. The first thing, we tried to gather investors, we tried to gather government officials, and listen from them what were the main concerns, the main problems, the main barriers, obstacles, what was in their mind, why things were not settled in amicable ways, or at least was not publicly known that they were settled in amicable ways. Out of there, well, we find out two main concerns, two main issues. You have heard before, first is lack of awareness, second is effective implementation of the existing frameworks. How to address them? Well, the first one, raising awareness, that's key issue. Because the lack of knowledge normally or frequently results in lack of confidence and trust. You don't know how it's going to work, you don't know what's going to happen, how it's going to happen, so you are a bit reluctant about it. How to deal with that one? We found two main tools there. First one, already mentioned many times, capacity building, and it's not enough. Still, this is a key issue, key tool, and more needs to be done. Yes, there have been a lot of trainings, seminars, workshops on investment disputes, investment arbitration, but not so much about investment mediation. This is happening quite recently. Secretariat has, in cooperation always with the same people, CDR, IMI, ICSID, developed some of those trainings, workshops, but still more is much more welcome. But for both government officials and also for the industry, we have to always remember that you don't settle if you don't have both parties at the table. And in this framework we have here also that there are also additional parties, civil society, NGOs. They also need to know how this framework applies, how it can be useful, when yes, when no. So it's important raising this awareness by capacity building trainings. Second thing is the guide investment mediation. You heard about it. It's publicly available since 2016. And the main idea was to have an explanatory document that can be used as a reference, but both by governments and companies, to try to understand better how the investment mediation works, and also to make up their mind or have a more informed decision on whether for that particular dispute they have in front of them, mediation could work. And if so, how can they prepare for it? This result of intense discussion and workshops with, again, ICSID, Chamber of Commerce, ICC, PCA, UNCITRAL, CDR, IMI. So a lot of people involved there, a lot of brainstorming and experiences. This is quite practical, main particular issues that they found in the day-to-day. Now, among other things, first of all, it clarifies what is investment mediation. For many, it's not quite clear. It was the first time they approached this situation. Now, how investment mediation fits in the whole picture of dispute resolution, investment disputes, then which were the main available rules, at least at that time. We see that there are more new rules coming. What is the role of the party and the legal representatives? What's the role of the particular party, CEO, and the lawyers of that party? What is the different stakes during the proceedings? What are the different steps or the main steps of the proceedings? And in addition to that, there were some tips or guidance or helping points for first assessing whether it is useful for your particular dispute to go mediation, how you consider that, how you propose it to the other party if you think that could be an interesting option, and how you prepare for the mediation. That means logistics, that means documents you need, how you made up your team, who should be there, who should not, and also, and I think it's quite important, elaborates on the supporting role on the institutions. And that's quite important because they can help securing the agreement of the parties. They can facilitate the understanding, the raising awareness when one party is willing, but the other party is not yet clearly into it. Can reinforce the confidence and trust of all the stakeholders. In particular, we have heard about the transparency, no transparency, but knowing the institution is there, that can provide additional trust and confidence. It helps overcome the initial hurdles and problems like visas for going to a certain different place or a meeting place, and that it could be neutral, administering the proceedings if needed, helping to identify candidates qualified for investment mediators, and also providing information on the cost. That's an important issue for the parties to know what amount of money would be involved for the proceedings. And then regarding the second main issue, main concern, one was the raising the awareness, the second one was about making sure the existing framework is really effectively implemented. Now, in this particular issue, there are four main tools or main topics that we can address. The first one, and it's key, is to have a clear domestic legal framework. In 2017, the Secretariat conducted a survey and analyzed different domestic legislation of members of the International Conference and tried to identify which were the potential obstacles or concerns behind it as an additional step of the initial surveys and works that we had. So the main findings, again, show that the main concern, the main problem, the main obstacle was, for most of government officials, the lack of a clear domestic legal framework. What it means first, there was ambiguous authority to settle or even to enter into discussions with foreign investors. In many cases, the state agency had to get ad hoc authorizations, and it was not comfortable, not confident whether that would be supported or not with their own internal legal framework. Second thing, as has been already mentioned before, is potential fears of public officials about later future arguments, allegations on corruption, abuse. How did you reach an agreement with that investor that you mentioned was so problematic? I mean, out of the blue, how this happened? And made that particular official in charge liable, and therefore trying to postpone or to push away the decision-making to a third institution. And of course, the lack of funding and how they are going to get the funding for the proceedings and who is going to secure the final stamp on a potential agreement involving money. Now, this also show a potential negative impact related to the absence of an early independent assessment of the dispute. What happened in most of the cases is that the notification of arbitration reached the government, and then at that point in time, it's not quite clear who will deal with that one, and at some point they rush into the arbitration. There is not much time to calmly consider in a neutral manner way whether is it possible to negotiate, maybe to mediate. Well, there's nothing to do, and part of it you need to go to arbitration. So you really need that particular assessment of what is the best way to go ahead. So because of that, in 2018, we work on a model instrument on how to manage investment disputes. Again, in close cooperation with many international institutions and government officials dealing with dispute resolution from Asia, Latin America, Europe. We also had a look at what was already there in some countries, and normally it was there in those countries who already faced several investment arbitration cases, and they had to react to it, and they had some basic domestic framework, but we saw many more possibilities. And talking with government officials, we identify many more practical problems that needed to be addressed. So the main aim of the model instrument is to provide guidance to the states. And the idea is to have an effective mechanism internally that will tell how to consider and how to deal in case they want to go for mediation or conciliation or any other amicable settlement process. Now, it tries to cover as many practical issues as possible, but again, providing many policy options, and it's up to the state to figure out on that big short menu, which is interesting, taking into account their own particular cultural, legal, administrative characteristics. It's not a one size fits all of them. So each country will have to figure out what works better for them in their realities and their circumstances, but provides a huge variety. Now, among all the different things that deals with model instrument, I will just focus on 5 main features that are relevant for investment mediation. The first one, already mentioned again, is to have a responsible body to coordinate. And that's key. When you talk about investment disputes, you talk about complex and quite difficult disputes that normally don't involve just a single state agency, but a variety of them. And therefore, you really need internal coordination. And this is crucial. Second thing is been mentioned, and it's a clear and express legal basis for the negotiation. The current official needs to feel confident, needs to feel secure that if they go to negotiation or mediation, if they settle, that's because the legal framework allows for that. And they know how that is going to happen and who is going to have the final authority to settle. That's quite important. Now, also related to what I mentioned before, to facilitate the possibility of an early independent assessment of the dispute, to be able to understand what's the most effective course of action. Is it mediation good for this case? Part of the case could be dealt by mediation or negotiation. That's key. Tension between confidentiality and transparency. You know, the investor, the state may have requirements, even if they don't want to, there are requirements of transparency. That's quite important to understand and to know how you're going to deal with that during the process. But from the very beginning, to have a press statement, if it's going to happen, to have an early strategic communication system. So you need to know that in advance. And also what is quite interesting and quite useful for the state is to have an organized, centralized, and consistent database, online database of what were the previous problems, what were the circumstances, how did you deal with them, and what actually worked. Because if you have that very important useful information, it will help you to understand better whether it's possible to reach an agreement or not, and if so, what are the different possibilities you may have to offer in the discussion with the investor. Now, the Secretariat is already providing technical assistance to some states in trying to implement this model agreement. Now, apart from that, I mentioned a couple of tools. First one was model instrument. Then we have updating the applicable rules. So the question is, there were already 1 or 2, 3, some rules there. The question is how to update them and to make sure that they are even more user-friendly and more useful for the process. You have already heard about the ICSID mediation rules, and you also heard about UNCITRAL is in the process of updating their own rules and the notes on mediation proceedings. An additional tool is the training for investment mediators, already mentioned before. I'm not sure if we have mentioned you, we have gone online already. This was the first time, was a great success. Again, thanks for the great efforts of CDR and all the involved institutions. And finally, and this was probably key more from the investor side, was enforcement. 2016, the NHT conference already welcomed the willingness of the connecting parties to facilitate effective enforcement of settlement agreements. Now, building on that, and more importantly that, is the UN Singapore Convention that has been already mentioned. Entered into force 2020, 47 signatories, 6 contracting parties, and that hopefully will facilitate enforcement of settlement agreements entered into with the state party. Of course, unless there is a reservation, that is possible, and actually at least 2 of those 6 contracting parties have mentioned, but it's a very good step forward in order to also provide a framework for enforcement of those settlement agreements that hopefully will have been implemented voluntarily by both parties. So this is a big overview of the main tools we have now and the main two obstacles that needs to be dealt with. Thanks with that, and I will pass the floor back to my colleagues.
Thank you very much, Alejandro. That was a great review of what you're currently doing. I'll next turn to James South, the Managing Director of CEDAR. James.
Great, thanks, Wolf. Let me start just by saying, for those of you who on the line who don't know about CEDAR, so we're unlike ICSID and ECT, we're a mediation organization. And so we were brought in to work with ICSID and ECT when this whole idea of investor-state mediation began to look like something that was worth exploring. And as everyone said, that was about 5 years ago now. And I remember going to a conference in Miami of a mediation arbitration organization, just as we started working on this and beginning to talk. I began talking about this project. And I remember many arbitrators in the room giving me either very odd looks or just saying flatly, this is just not going to work. So it's interesting to hear from Meg Kinau's keynote speech saying that the reasons why she thinks the time has come for mediation. And I have to say, from my 5 years of working on this now, there are a number of signs for me which really indicate why I think this is going to work. And so what I would like to do in my time is look at our mediation experience and when mediation services and initiatives have been successful and why, and then map that to what's been happening here in the investor-state investor-state mediation arena. I've worked in a number of different initiatives on mediation in specialist areas in the UK and in about 40 different countries around the world. And some have been successful, some haven't. And it's led me to distill 4 key things which need to happen kind of at the same time in order for the mediation to develop. And I think these 4 elements are present, as my colleagues have all talked about, in relation to investor-state mediation. So the 4 things that need to happen are substantive process, system, and structural reform and institutional reform. Second, you need a capacity building, the development of a competent body of mediators to mediate specialist case. And importantly, you need lawyers and the representatives, so in this case, state officials, to understand and be trained in being effective in the process. The third area is clearly broad awareness raising. And more importantly, you need key ambassadors and champions in the relevant stakeholders who are going to be responsible and influential in moving it forward. And finally, and Meg touched on this in her presentation, you need successful mediations to happen. We can talk about it, we can train on it, but really only when you do it does the light bulb go on, when people really say, oh, now I really get it. And of course, when they do that, they then speak to their lawyer colleagues or their ISDS colleagues, and then it begins to really develop from there. So let me sort of just map the development, what I've seen in the IS mediation field to those 4 areas. And I'm going to mention some of the things that my colleagues have already mentioned, but I'll maybe go into some detail in some particular areas. So let's start with substantive process, system, and structural and institutional reform. Well, you've heard the work that's been done. I mean, first of all, the work that ICSID is doing in terms of its mediation rules. And what I have liked about what their work is that they have really worked hard to strike the balance between clearly taking the best of the arbitration approach and the rules and giving certainty and comfort to states and investors who were used to that side of the ledger, but also working hard to make sure the language and the approach also has the mediation elements that signal a different approach. And I think the rules have worked that really fine line. And I know I know Frauke has and others have worked very hard to get that balance right. So that's a really good sign. Clearly also ICSID are supporting it and offering this service, and as Alejandro has said, and Mark and Frauke, it's important that institutions who have the confidence of the parties are providing that service so they have somewhere to go. And we saw that in commercial mediation in the UK. I mean, both in terms of commercial mediation wasn't happening in the UK until the Wolf reforms, the civil procedure reforms, changed the rules in court so that the parties could encourage mediation. So that was a rule change. And then you had the institutions there like CEDA and others who were able to provide the confidence for parties to say, oh, let's give this a go. So I think those things are key. And of course, you've also had in the investor-state area, the UNCITROL work and Working Group 3 in terms of the reforms, which is also looking at mediation and other forms of dispute resolution. And of course, finally, ECT, as Alejandro just talked about, the protocols and those sort of things, all again, add credibility at an institutional and process level. But that's not enough. You need to go to the next level is, okay, you've got those in place. You then need a competent group of people to be able to go into the mediation process. And I'm not just talking about lawyers, mediators. So we've talked about the mediation course, which has been delivered in Washington, Paris, Hong Kong, and last week virtually online. And it covered all the things that Mark set out in the competencies that IMI developed. So you have the stakeholder mapping, you have understanding of the ISDS context, process design. This is a complicated process with complicated parties and complicated dynamics. It isn't just a one size fits all. It's going to have to be designed up. Issues around culture and ethics are also touched on this course. So we've begun that work. I did want to say one thing that's really important. Mediation is a skill which is learned. It's not one which you just assimilate by talking about it. And just like you wouldn't put a unlicensed driver in a Formula One, or you wouldn't put a lawyer, a non-lawyer in front of a court to argue a case on behalf of a client, so you shouldn't put someone into a mediation, particularly a complicated investor-state mediation, to mediate that case. Now, I'm not saying that, so this is not saying that people can't be mediators and arbitrators. I know many arbitrators around the world who are very effective mediators, but they are trained as mediators. And I think that's a really important point, that this is a complicated skill set and you do need to be trained in it. So whoever the mediators are, and I don't have any views on whether, I think there should be a wide range of mediators in the traditional market, arbitrators in the ISDS world, other people as well, but they need to be trained. That is the key. In terms of training, the other point which is important, and we've seen a lot of interest, is the government officials that we've worked with in Hong Kong and other parts of the world, and in Brussels through ECT, really have a strong interest in this. And when you begin to work with them, they really begin to understand how this can help states to resolve issues in maybe a more effective way, retain the important commercial relationships, and encourage FDI, as mentioned by Meg. So again, training of government officials, and we're working on programs to do that virtually and face-to-face. So any government officials out there, then come and speak to ICSID of CEDA or ECT, because that's something we're looking at. I think the final area on capacity building is lawyers. Lawyers in mediation, it's a different skill set. And if you're an arbitration lawyer, being effective in arbitration is one thing. Being effective as a lawyer in mediation is another. And I think we need to support the lawyers and encourage them to give them confidence in the process, because they play a key role. You can't do this without the lawyers. And just so it's clear, this is not about sidelining lawyers. This is about including them in the process to help their clients resolve these types of disputes. So that's the capacity side. And one final point on the avoidance. I mean, I think, again, I know UNCITROL are looking at this, and And the IFC came to us a couple of months ago and said, well, we really want to support investment officials who are working in aftercare, as Frauke said, to try to manage disputes before they actually become full-blown disputes in the ISDS context. So we've done 3 programs in different parts of the world virtually because of coronavirus, supporting officials to have those skills to manage emerging conflicts and disputes. And I think that's an important part of this whole overall move to improve the ISDS environment. So the third area which I'd like to touch on, which is awareness raising and ambassador and champions. I mean, I think we've covered a lot of that already, and you've heard of all the things that have been done. But it is amazing to me, and I think this conference is sort of an example of that. You know, we are now having a 2 half-day conference on investment state mediation alone. But I've lost count now of the number of times I've spoken about this topic in the last, few years, from Abu Dhabi to a lot of online stuff. IMI, we've done stuff with IMI. So just clearly there's an interest there. And what's important is that we have ambassadors and champions that are developing. And it's great to see people like Meg here as Secretary General of ICSID supporting that. And there are many others as well. I know there's interest in relation to China and the Belt and Road Initiative and other areas like that. So the more that we can have ambassadors saying this can work is really important, I think, for the continued development of the field. More needs to be done. I think we need to engage more with the ISDS arbitration community and really answer the questions and doubts and concerns that they have. It's normal to have those concerns, and yes, there are very real challenges, but as Mark and I will know, I've heard the number of times I've heard in particular areas of particular countries, this can't work because I would probably be a richer man and wouldn't need to continue to mediate. There are always problems in areas, particular areas. I remember working in a tax mediation area, and all the tax officials told me why we couldn't do it. And now there's successful tax mediation in the UK. So these things can be worked through with a little bit of thought and putting the collaborative the thinking caps on between the respective communities. And I think the final area then is we need to get these things to happen and mediations to happen, as I said earlier. We need to make sure that mediations happen, and then the light bulb moment will begin to happen. And then you see things slowly beginning to increase in speed because people have the confidence, as Meg said, that this can work. They go away and talk about it, lawyers and representatives from both sides of the investor side and the state side. Credibility increases, and then more mediations begin to take place. Is the general trend in development of mediation in particular sectors. And I think we're beginning to see the early signs of that also. And I think tomorrow we're hearing from Mercedes Tarazon, who mediated an investor-state case, and I know there's some discussions about others as well. So I think finally for me, I did want to say that although there are obstacles, they all can be overcome. And all the signs, as I've indicated, under those 4 areas, for me, show that this is very likely to happen and to continue to develop. And I think I'll leave it there.
Right, thank you very much, James. That actually puts us well then into the questions. We have a number of questions that have been raised, and I would ask Jarek to perhaps lead the Q&A function. Jarek?
Jarek might have frozen.
Jarek has connected, right. But perhaps then let me kick this off again. the Q&A function allows people to vote on the questions they'd like to have asked. So if I could just ask, Liam, perhaps can you have Anne van Aken be put on the panel so that she can ask the question? Thank you. Anne?
Yeah, hello. Hello to everybody. I just very quickly wanted to ask, when I was working with Catherine on the mediation working paper for the Academic Forum for the UNCITRAL III working group, I was looking at the Council of Europe projects on mediation, and they do have a lot of work on that, including less so, but including mediation of administrative disputes. So it's all about the domestic framework which states have. And I was wondering whether the ECT or ICSID or any other organization working now on IS mediation is also trying to somehow get the data and the information of the Council of Europe, especially given that the membership of the ECT and the Council of Europe has a huge overlap. Thank you.
Thank you, Anne. Do you want Alejandro perhaps to kick that off? What's been your ECT experience with that?
And so, well, not too much for two reasons. The first one is we try to go to the practical concerns of the individuals that normally will have to be there. So we try to deal with those foreign officials dealing with dispute resolution and to see what was their actual problems, their actual practice, even if we actually also look at the legislations and we look at what were the existing documents. I wanted to know exactly directly from the people involved. That was the first thing. Second, once we have a draft, we try to involve the Council of Europe, that it was not within their priorities, this area of mediation with investment disputes. It was not at that time, 2018, not in their priorities. So they were informed, but there was not much follow-up on that.
Anyone else? James, Frauke?
Yeah, maybe I can say. So ICSID directly has not worked with the Council of Europe, but I know that my colleagues from the IFC who work in the investment climate unit have done studies and presented them for the European Union, and my understanding is also for the Council, on the investment dispute management, effective tools, how to address disputes early, and that includes the domestic legal framework within the systemic response mechanism, investment response mechanism that the IFC had developed. And there, the Europeans are obviously very interested in an effective tool for outward flow of capitals in other areas of the world, and that is then addressed then from the other side as well with our IFC colleagues and the programs that we have trained the government officials in. So that's to add.
Can you just...
I'll just add, I mean, the only thing that I know, just in terms of, I know that we're often asked, and I have been asked by the European Union and the Council of Europe for statistics in relation to the use of mediation, and in particular sectors, for example, in infrastructure. And they've been looking at how this could be used as a framework. So I know they're interested in it and always looking for hard data, which CEDA sometimes can provide.
And is the ECT data online? Because I haven't seen it, but maybe I missed it.
So what we have online is the model instrument, the guide on best mediation, and I think we have some news items on the different workshops we have conducted. They are most of them available in the unchartedtreaty.org website, when we also have additional relevant documents. But we have not made public, of course, all the internal discussions with foreign officials or the industry in workshops and seminars, only kind of summary, since those were always to make sure that you get all the real input. They were only on confidential basis, so to say. So we only provide what is the summary result, the main conclusions achieved, and the main concerns raised during those meetings.
Okay, thank you, Anne. I wonder if we can now move to Catherine Casadian.
I was actually going to get a book. You caught me off guard. Thank you, Wolf. I was actually interested in hearing panel members on the question that was raised during Meg's presentation, and where she said she was of two minds about the what I call the knowledgeable. In French, I have this expression, which is le médiateur savant or sachant, which is the knowledgeable mediator, the mediator who knows the field, who knows the substance. And I just wanted to hear you, if you have any position or ideas or whatever you want to say on this. And afterwards, I may actually say what I have in mind, but I don't want to, focus the discussion on my own ideas. Thank you.
Thank you, Catherine. Maybe Mark, if we could start with you.
Broadly, this goes to the question of who will the mediators be? And I think there is a fair chance that they will come from varying backgrounds. Some of whom will be public international law trained, experts who have good mediation skills. Some of whom will be commercial lawyers, international commercial lawyers who have excellent mediation skills and need to be trained up, as James has said, on ISDS issues. So I think they will come from a variety of places. And it almost goes to that question that was asked earlier about, or that James alluded to, which is, will investor-state arbitrators make good investor-state mediators? And the question for me always is, or the answer is always, it depends. Some will be excellent, some will not be so excellent. There is something to be said for having real expertise and experience, because it makes you more credible in terms of the selection process, I think. On the other hand, if you cannot allow the parties control of the process and the solution, then you have a problem on your hands and you're probably in the wrong forum.
Mark, can I add? I think the other thing to say is, of course, given the complexity of these cases, co-mediation is anticipated, and I think I agree with you, Mark. Having someone with a specialist knowledge, maybe from the arbitration background or from the ISDS background. But the other key thing, which I think is going to be really challenging, and it's alluded to in one of the questions, is the issue of process design. So there, an international commercial mediator or someone who works in cases which involve those sort of things, like the indigenous rights cases that Meg mentioned earlier on, or complicated labor cases with multiple parties, where international commercial cases, mediators who have that experience to process design, that's also really going to be key, because it's going to require quite a lot of flexibility in that sense.
And maybe I can add, sort of from the ICSID conciliation experience, we haven't spoken much about it, but the drafters indeed envision conciliation as an amicable tool to settle disputes. And what happened through practice is that one of the first reports by a commissioner stated that he understood the role of the commission was to evaluate the case on legal basis as it would have happened in local courts. And that was not the intent of the drafters once you go back to the history, but that is what then was duplicated, you will understand what I mean, in subsequent conciliation. So I mentioned that to underline that the importance of understanding the process is really there. And as James had mentioned, mediations and mediation skills don't come from reading books, but from having done it, and having done it in a complex setting involving public entities. That's the important piece. And that that is where what Meg mentioned earlier, the early neutral evaluation might fit in, that if you want an evaluative process that's outside of an arbitration, then perhaps that might be better suited.
Catherine, did you have a follow-up or?
Do we have the time? But because there were many other questions. So.
Yeah. No, I thought you wanted to make a comment, but that's,
no, I do. I mean, I do have my own ideas, which are not entirely the ones that have been aired by the panel. But let's go to other questions, and then if we have the time, we can come back to that.
Catherine,
thank you. Thank you all.
Yeah, thank you. All right. We had a question from Thomas John as well. If you could perhaps put him on the screen. Well, maybe I'll just pose the question. It's actually perhaps one for you, Alejandro, and the model instrument. Tom stated that in my opening, I talked about there being different types of states and the importance of ascertaining the viability of mediation in those states. I guess he's referring to the comment of rule by law versus rule of law states. How would your model instrument be utilized by different states with different political structures?
Well, I think the main issue is that we provide different options that they can contrast and have to reality check in and see that those options or any of them will work or not within their own structure. Some states are small with a small bureaucracy, and then they cannot have a coordinated committee with different ministries involved to follow up the discussions. They can only have one person, one department at most. Some they can have a full team focus on potential investment disputes, then gaining experience and practice, where others will not be able to do that, and they will always have to refer to either external law firms or some other arrangements. So the important thing is that it is for each state to consider, based on their cultural background or legal background, realities, what will work better for them. And the main point is looking at what they have now and taking into account what are the main things we consider could be relevant to be prepared for, that they go through the process, they analyze that, and they try to understand whether it can work or not. We have seen also governments that they have already big ministries and they consider that the current situation works well with them in case they receive a case. Others, they start working on it and then they try to fit within their structure what will work better or not.
Thank you. Tom, are you there? Because I know you had another follow-on question. Well, if you're not Tom, while we're just on Tom, he had another question, James, that you might be able to answer. He asked, with respect to process design, could you perhaps give some example of how that might work, given that cases are very different from each other?
Yeah, I mean, I think that our training program touches on this quite a lot. I mean, the first point is stakeholder mapping and design, understanding who the parties and the stakeholders, both represented in the mediation itself, but we talked about third parties potentially who will have an impact as well. So understanding that and their potential interests. Thinking about issues around language and culture, we've already touched on. And I think, as the point has already been made, given the acceleration of the use of online mediation, given the pandemic, and given that these cases are likely to go over a series of sessions over a longer period of time rather than on one day or a group of days, the combination of the hybrid use of online and face-to-face, and thinking about how those sort of things will play out. So those are some examples. There are many more in terms of sorting out issues around authority, how you include community groups and the like who need to be pulled in. So there's a number of those types of factors which need to be factored into process design.
Great, thank you, James. And we had a question from Hikari Saito. Hikari?
Yes. Hello, everyone. I'm a PhD. Oh, okay. Does this? Hello.
Yep.
So I'm a PhD student from University of Aberdeen, and my topic is not very investor-state arbitration, but I have worked on the Singapore Convention and mediation, and then I see the development of mediation is based on the very court encouragement of mediation and an explanation to the parties to understand what is the benefits of mediation. And then I guess probably same thing can apply to the investor-state mediation. And I was wondering if there was any discussion at the ICSID when they were drafting the new mediation rules about whether the tribunal will may refer to the refer or recommend the parties to use mediation or as a ADR. Thank you.
Yeah, thank you. Thank you for that question. Yes, we have discussed it. We've had discussed it, whether we include specific reference to mediation or to other processes within the arbitration framework. And we come to the conclusion that we did not want to do that. We wanted to establish first a clear mediation path before creating hybrid processes. Having said that, what you see in practice, and Meg mentioned that a little bit, is that after decisions of liabilities by arbitral tribunal identifying that there is liable, there has been a breach, we see in a number of cases, I believe 5 in the last 3 years, where the tribunal then invites the parties to take a specific amount of time, let it be 3 months or 4 months, to discuss in light of that decision whether they could reach a settlement agreement. So I think by that awareness raising, by identifying different ways how mediation could assist an effective dispute settlement option or investor-state dispute settlement, that is triggering or trickling into the arbitration mechanism.
Great, thank you, Hikari.
Well, can I say something?
Yes, of course.
You know, it struck me when Frauke was talking about the rules and the provision for parties inviting the other party in, and institutions' role, and I think it's a good one, as a convener, you know. I think all of these things will be easier with policy. So it's a lot easier for an investor or for a state to offer mediation when the state is on record as saying that we favor mediation as a way of resolving disputes. I think one of the great benefits of the model instrument is by making mediation a topic that is known and accepted within a particular state, parties are more likely to use it. So one of our biggest challenges, I think, is to further that process.
And you mentioned the Singapore Convention work on that, Hikari, and that is where there is a real halo effect. The discussions on mediations have been ongoing for the last 10 years in this context. And there was a question in the chat on the applicability of Singapore to investment disputes. And I believe Wolf has done a podcast on this actually that you may wish to listen to. But there are different indicators in the drafting history, in the preamble. Alejandro mentioned the reservations and the link from the definition of commercial to the ancestral model law, which then includes investment, that investor-state disputes were not meant to be excluded. And the Singapore Singapore Convention then had within this discussion and the awareness raising a real halo effect on that. And maybe Mark, would you like to speak to the IMI survey? I think there was a real interesting survey a couple of years ago about why companies may not engage in mediation in the commercial context and how Singapore there might have addressed these concerns.
Well, in fact, it was a global pound conference in 2017, where I think one of the biggest outputs by the conference was that confidence in mediation would be significantly assisted if there was an instrument for the enforcement of mediated agreements. And so certainly the investor community spoke very clearly to the desire to have policies in place and to have a statutory basis for enforcing mediation awards. So Frauke is right. The Singapore Convention is going to increase the acceptability and hopefully acceptance and use of the mediation process. Finally, states do have an opportunity to opt out of the Singapore Convention, even adopting it. And I have done many of these conferences now where I've suggested that's a lost opportunity. Foreign direct investment is going to be more likely where a state does not opt out, where a state says we will be party to these, to this process.
Yeah, thank you very much. And again, Hikari, thank you very much for your question. We'll now turn to Brian Chang. Brian, are you on?
I am, yeah.
Thank you.
Thanks, and thanks everyone for an excellent discussion. So I would appreciate it if the panelists could share your views on what should be prioritized in terms of promoting mediation over the next few years, besides, as previously discussed, the need for more case studies of successful mediations, bearing in mind, all of these positive developments over the past decade and ongoing capacity building efforts that you've been involved in. What else should be done now? Thank you.
Who wants to start with that? James, do you want to start with that?
I think the confidence of the parties in using the process prior to actually doing it. So the work that we can do, and Alejandra's mentioned it, and others, for example, upskilling and giving state officials, the ones who will be representing their governments in the mediations, giving them confidence to understand how the process actually works, and their role in it, and giving them confidence that they can be effective. I think that's really, really key. And also getting the arbitration lawyers and community generally to understand how this is going to work, and also making sure that they're comfortable with their role in it.
Another aspect, what Meg had mentioned already, is I think to work on provisions for treaties or contracts that provide for mediation. And here there is a lot of interest. When I presented the mediation rules to our membership last year here in Washington, the discussions were as specific as, okay, how would it look like? How do we write our clauses in our new BITs that we are negotiating to make room for that? And here to learn from the past, where a number of provisions, especially when they refer to ICSID, refer to either conciliation or arbitration under the auspices of ICSID, and to look at that this is not an either or, but it's standalone process that can be used instead. So that's another area.
All right, thank you very much. We've got time for one more question because we're going to have a quick break before the next panel goes on. So Athena, thank you very much for joining us. Athena, would you like to pose your question?
Thank you very much. Hi all, I am Athena Stafaila from University of Munich. I do research there. I want to ask something about the intra-EU BITs. They are now declared after the Achmea decision of the European Court of Justice as non-binding. And recently we had another development. An EU member state issued a question to the European Court of Justice to the compatibility of Energy Charter Treaty with EU law. And now we have a new conditions in Europe, and I think investors are left completely uncovered in all these BIT, intra-EU BIT treaties. They are not binding now. So what have to do now? Is there existence a need to develop new EU mediation mechanisms? Because there is this flexibility and this security for both parties. They can opt out. We have already discussed that when a party is mistrustful, can opt out or can develop a new tool in the mediation. Should we try now to develop new instruments, international intra-EU instruments, especially for intra-EU, for EU member states and investors, mediation mechanisms, specially developed, tailored for EU member state and investors? Thank you very much.
Yeah, thank you, Athena. Before we turn to the panel, perhaps I can just mention that this past summer through IMI and the task force that Mark was talking about, we actually submitted our comments to the Commission, because the Commission had asked for comments with respect to what they should be doing now, given the current situation with intra-EU BITs not being enforced anymore. So we actually did promote mediation in our comments. So that's one of the activities that we've undertaken. But Alejandro, do you have any comment with respect to ECT or do you feel comfortable making any comment on that?
Well, not in relation to the ECT as such, but I think it's still important, even if European members, not many of them, they have a clear internal framework. I think that's the first step. The first step to any mediation is to make sure that the country has already the internal framework saying when and how they can enter into negotiations, discussions, mediation with a foreign investor, on which basis, who has authority, how to get the process for agreeing on that. You may go for then the rules. You can choose exit mediation rules. You can choose anything you want to. You may have an intra-EU special mechanism. But if you don't have the internal framework within the countries, that's one of the major concerns. And I think that's the first step. And as Walt said, the Commission Financial Services already are looking into that one. Mediation is one of the main options to go ahead. But you first thing need to make sure that internally every single country will have the framework and they know how to, but also the foreign investor knows how to. And it's publicly available and it's understandable. And that will be the first step. Without that one, it's very difficult to go anywhere.
Yeah, thank you, Alejandro. I'm afraid we're out of time because we want to make room for the next panel. So that leaves me to thank everyone on this panel. Excellent discussion, and I think people have a better understanding of what is currently occurring with respect to mediation in this landscape. So thank you again, everyone, for joining us. We're going to take a very quick break. We're going to start again on the hour, and panel 2 that is chaired by Charlie Reese is going to be the next panel. So thank you very much, everyone.